for the next hour and 20 minutes. We have two different extremely interactive processes that we're going to undertake. And the first one is the LARP, live action role playing. And if my partners, Emily Massey and Justin Hill, will go ahead and join me for the LARP session. This is typically when we're in person, is one where people at the tables each have envelopes, and each person plays a different role, and we go through different scenarios, and depending upon the answers, it dictates the outcome of the situation. And we got to do it a little bit differently during the virtual presentation, but what we decided to do is something a little bit different. I don't think you'll find any of these questions we're going to ask you to answer very easy. And these are the same analyses that as employment lawyers we go through on a day-to-day basis. And we get a lot of calls from folks, and they give us a 2 or 3 sentence narrative and then say, can we terminate the person? Well, there's a lot more to that situation than 2 or 3 sentences. And so we want to kind of help you get into the mind of an employment attorney when it comes to answering these questions. So, and I do want to point out, every single scenario in our LARP today are real live scenarios that we have dealt with advising clients, and we've just tweaked them ever so slightly to protect the innocent. But these are real life questions that we've dealt with in the last several months. And so join and make sure we want everybody to participate. So if you will text to the number 22333, the message EMP Law, EMPLAW. So text 22333 EMP Law, EMPLAW. You will be able to participate in answering the questions in our LARP. So my colleagues today are Emily Massey, and Emily is just amazing. Every attorney in our section works with Emily very closely because she is just so good. And she does essentially everything that you could imagine labor and employment wise. She is an expert with personnel policies, handbooks, background checks, discrimination and harassment issues, employee discipline, termination, drug and alcohol testing, and wage and hour issues. She's also one of our experts when it comes to employment related education law. And Emily, prior to going to law school, had a 4-year career at Capstrat, which is a full service communication agency doing public relations. So she is just a pleasure to deal with, folks, and she's so pleasant, but she absolutely has the heart of a tiger when it comes to litigating cases. And so I'm glad I'm on the same side as she is. And then our next participant is Justin Hill. And I'll tell you this about Justin. In law school, his last year, he and his team at Campbell Law School participated in the Hofstra Medical Legal Mock Trial Competition, which is a national competition, and won it. And so Justin joins us as a national champion, and we have been given Justin just an absolute smattering of different labor and employment issues. And so he is very quickly absorbing everything, and already is taking some lead chair roles with some clients. And, we're just really excited about what Justin brings to the table. So with that being said, why don't we get started with some pretty interesting scenarios? I'll turn it over to Emily.
All right. Good morning, everyone. And thank you, Ken, for the welcome and introduction. So our first scenario, we're introducing you to our employer of the day, which is Busy Bees, Inc. We're very on brand. Busy Bees, Inc. has 400 employees and operates in several states. Busy Bees has had difficulty with employees wanting to work remotely since the COVID-19 pandemic began, and it has recently decided that all employees in all of its locations must return to their respective offices as of June 1st, 2021. Busy Bees also decided to mandate that all of its employees must get one of the COVID-19 vaccinations.
So for this first question, we want you to type in, this is an open-ended question. So after you've already texted to make sure that you can join in, type in any issues that Busy Bees should take into consideration with implementing these policies.
ADA. Yep. Discrimination. Reasonable accommodations.
Yeah, I think people are picking up on the issues with the mandatory vaccines and whether we can just mandate something, or do we have to consider certain exceptions to the mandates. I love somebody saying consistency is the key. They've obviously heard others speak earlier today. Okay, I think we're getting it. Everybody's hitting the right notes. So let's continue along this line. One of Busy Bee's employees, Sarah Sting, is a graphic design artist who has worked from her home since being hired 5 years ago. When she receives the return to work email, Sarah informs her HR manager that she does not feel comfortable coming to the office because she is on immunocompromising medication. She also is highly prone to anaphylactic reactions and is hesitant to get the vaccine. In addition, Sarah has a special needs child who has already been approved for remote learning for the upcoming school year. Sarah requests that she be allowed to continue to work remotely. What should Busy Bees do? Choose what you believe to be the best answer. And just running through the answers, the options are A, Busy Bees can outright deny her request because of the business necessity of getting employees back in the office and avoiding any claim that it is granting Sarah special treatment. B, Sarah can terminate, Busy Bees can terminate Sarah if she refuses to get the vaccine. C, Busy Bees must accommodate Sarah. D, there are multiple correct answers. E, there is no correct answer. And F, not sure.
So I can see we've got a few answers that are starting to roll in. Give it just a second to see if we get some balancing out or if other answers are chosen. Well, I see we've only got 3% right now on answer choice A. Busy Bees can outright deny her request because the business necessity of getting employees back in the office and avoiding any claim that they're granting Sarah special treatment. This answer may be one that a few people lean towards, but the problem there is, as Tom Colclaw was talking to Devin earlier, you need to go through the interactive process. So communication in this situation is the big drawback, making A not a correct answer.
Okay, it looks like we did not get anybody taking us up on B. Busy Bees can terminate Sarah if she refuses to get the vaccine. There certainly are circumstances in which, if you do have a mandatory vaccination policy, that you can potentially terminate an employee. But here, given the issues that Sarah has raised with immunocompromising medication and anaphylactic reactions, you must at first engage in the interactive process to determine if you can provide a reasonable accommodation. Now, if you participate in that interactive process and determine that we cannot accommodate her, and if her job should be one that she does at the office, then we could terminate. However, this person was working remotely even before the pandemic. So that's going to be a hard case to make that we should not accommodate her going forward. So B is not going to be correct.
For C, it looks like that's our most popular answer. 57% said Busy Bees must accommodate Sarah. And I think based on what Ken said, I think that might end up being what the company decides to do, but to parse the words like us lawyers like to do, must Busy Bees accommodate, I'm not sure if we have enough information here, right? Because she is on an immunocompromising medication, but we don't really know if she is qualified as a qualified individual under the ADA. So the company may not be legally required to accommodate her. Begin, they have to engage in the interactive process, and it may end up that the best business decision or the best legal decision is to accommodate her. It may not necessarily end up being that they must accommodate her, but like Ken said, the fact that she was working remotely before, if she is a qualified individual under the ADA, they're probably going to need to allow her to work from home.
And with answer choice D, we see there are multiple correct answers, and that one was second in the running from the percentages so far. As you can tell from the different explanations that we've gone through with A, B, and C, D may not be the best answer just because there may be bits and pieces of each answer that you pull out to get to what is the best strategy to take to accommodate or handle Sarah's situation. But saying that they're all, there are multiple of them that are outright correct is not correct.
E, there is no correct answer. And we did get some folks that said that, and you could take that position and you may not be incorrect in taking it. In this situation, obviously the company is going to have to engage in the interactive process and determine if it must accommodate Sarah. And there could be additional facts that we just don't know about that would, potentially change our opinion. So E is a possible correct answer. So I'll leave that statement right there, and then we'll deal with the last one.
The last answer is not sure. I'm surprised no one picked that. I think that was my answer the first time I took this. So glad that everyone feels confident, even if your answer was what Ken just went over, which is there is no correct answer. And I do think that's I think to me D and E are probably are kind of both the right answer. And if you're not sure, that's okay too. These are tricky.
So moving on to our next scenario, leadership at Busy Bees has determined that it should become more diverse in terms of women and people of color in supervisory positions. The CEO issues a mandate that no supervisory position can be filled without considering whether a currently employed woman or person of color can fill the role. The CEO has indicated that Busy Bees has a goal of increasing the percentage of women and people of color in supervisory positions by 40% and 25% respectively, which mirrors the percentage of those demographics in Busy Bees non-supervisory ranks. Finally, the CEO has indicated that year-end bonuses will be dependent upon these promotion percentages being achieved.
So please type any concerns you have about this diversity initiative. Discrimination, discrimination, discrimination.
3 in a row.
Disparate impact. Oh, yes. Incentives may be an issue, okay? EEOC. Discrimination. Mandatory percentage increases. Too much to type. Oh, okay. Person sees a lot of issues with it. Adverse impact. Okay, excellent. I think folks are thinking in the right terms.
So let's go on to our next question. This initiative has caused an uproar with many white male employees who believe that their promotion opportunities have been restricted. They argue that hiring officers are financially motivated to discriminate against them. Some have taken to wearing shirts with slogans such as "White men matter" and "White men deserve promotions too" in protest. The CEO issues an edict that employees wearing these shirts will be disciplined because these shirts undercut Busy Bees diversity initiatives. Over the last year, Busy Bees has allowed employees, regardless of gender and race, to wear shirts with messages promoting women's and LGBTQ+ rights, as well as shirts denouncing white supremacy.
So based off of that, should Busy Bees proceed with their diversity initiatives unfettered and maintain its practice of silencing employees protesting against these initiatives? And it looks like as more time rolls in, the yeses are slowly dwindling down.
Okay, it looks like we're at about 93% says no, they should not proceed unfettered. Okay, and I think that's probably the correct answer. So on the next slide, please type why you chose your answer, yes or no. Why should, if you believe they should proceed unfettered, which, you know, many companies are proceeding in that capacity statewide, or if you think they should not proceed unfettered, then explain why as well, just in a couple words. So discrimination, it's not right. You're not treating people consistently. Inconsistent application of speech mandate.
Right, and that you may have heard of the, you know, the Whole Foods case that was in the news a lot about not allowing employees to wear Black Lives Matter face masks. And I think the person who's saying, you know, the consistency, if you're going to allow wearing masks or t-shirts, being consistent and allowing any message, so long as it's not, you know, profanity or something in that respect.
And you certainly can draw the line in regard to things that would be true hate speech and things that would incite violence. Now I see one that's I like. It says white men are not protected. Okay, now, you know, there is that sentiment out there, but let me say this. Title VII talks in terms of individuals not being discriminated against based upon, and you know, the whole laundry list: race, sex, gender, age, religion, national origin, all those. It did not say a particular race. So all races are protected under Title VII, and this is getting back to what Tom Colclaw was speaking about. You do not want to have a situation where, say like in your DEI training, and we're getting ready to talk about that in our next part. So maybe I'll just hold off and we'll go through that one, and then I can pick up on that. So let's see, Emily, are you the next one?
Yeah. So let's move on to, we're still talking about Busy Bees. The CEO decides that the company needs to have mandatory in-person DEI training sessions and announces that a nationally recognized expert will make a series of company-wide presentations. Some employees look up the expert on the internet and determine that she has controversial opinions. They then decide that they will have been potentially exposed to COVID-19 and need to self-quarantine on the day the speaker is at their respective location. The CEO gets wind of this plan and announces that anyone who misses the meeting will be disciplined severely.
So with the discipline piece of that, do you have any concerns about the CEO's plan? So it looks like we're resting right about like last time, where we're at 93% of the yes and 7% of the no's, give or take a few answers as they roll in still.
So why did you choose your particular answer? Give us a few words explaining.
And just as a reminder, disciplining an employees for not coming to the mandatory DEI training because of their exposure to COVID-19.
And now I'll talk about some of the things we've been alluding to previously. We do not believe that policies and training that singles out any particular race in an adverse capacity is a good idea. And that includes white people. Training that basically makes white people feel bad just because of the color of their skin for the historically terrible things that happen to minorities is not the way to go about a successful DEI program. If you take that approach, you're going to alienate a segment of your population, and they're not going to hear the message that you want to have conveyed. Obviously, the message that we want to convey is one of inclusivity and not one of putting people or pigeonholing folks into slots that you're a bad actor just because of the way you were born, and you're the problem that's caused all this social justice or social injustice. And so that's not appropriate. And frankly, that, as Tom mentioned and as Xavier mentioned, could be a potential claim that for race discrimination that a white person could file. So you have to be very careful there. Anything else you want to add in?
Yeah, I thought there were some really good comments just in the one before and this one about losing good employees and morale. I mean, and that's always important to keep in mind. I know that, leadership and management, I know all of you as HR professionals and legal counsel, you have to think about the business side, right? And you may have the CEO or management saying, I'm really passionate about this and I really want to take this position. And a lot of you said, why can't we video the training? Why can't we have other options? And there might be these circumstances where for a business reason, management wants to take this position, and it's important to keep all these tools and these ideas in your back pocket to have those discussions of, I understand, but we have to think about discrimination. We have to think about employee morale and be a little bit more flexible. Someone mentioned collective action, and I'm wondering if that was Grant. And that is really interesting. And I think in this circumstance, if the person's lying about being exposed to COVID-19, that would not be valid. But in the background of it, in general, of employees acting in concert and together complaining to each other, saying, we don't agree with our working conditions, our terms and conditions of employment, there would be an argument that these white male employees are coming together and saying, we don't feel like we're being treated fairly. That could rise to a National Labor Relations Board complaint. So I thought that was a great point. The one thing no one's really, a couple of people said, COVID exposure. Yeah, I mean, we still need to be cognizant about that, right? If someone has really been, if they have a legitimate excuse, and get that doctor's note or get some information from them and a statement from them saying that they truly have been exposed. So those were my thoughts.
And I think it's been mentioned that the anti-retaliation provisions of the FFCRA expired at the end of last year, December 31. But does that mean that there's no retaliation of claim available potentially, depending on what state we're talking about, Justin?
Not quite. There are actually a few states, and I think this is something that we'll see some of in our next example as well. But there are a few states that have gone out and they've taken it upon themselves to make sure that they protect. So things such as paid leave for people who have to go out for any sort of COVID exposure, or paid family leave for people whose families have situations or their children's schools closed. And they do have anti-retaliation portions within those laws that we need to make sure we, think about, especially for multi-state employers, as you want to adopt a policy, but you want to make sure that your overarching policy works everywhere, or that you have an addendum for the states that you need them in.
And Emily Grant sent a message saying it was not put that in there. So somebody from the audience did that.
Has been listening. Okay, good. I think we can move on to our next one. I love this name that Jen came up with. Willie Wax, who has been fully vaccinated, actually was exposed to COVID-19 and gets the news of his friend's positive test the night before the DEI speaker is to present at Willie's North Carolina location. Thinking he is complying with CDC guidelines, Willie calls in to inform his supervisor that he will be out of work and will get tested. Thinking that Willie is making this story up, Busy Bees decides to make an example out of him and terminates Willie. Willie sues Busy Bees.
So with this one, the answer choices are going to be about who wins and why. So Busy Bees wins because Willie lives in an at-will state. Busy Bees wins because an employer has a right to take action, even if it is done under a mistaken belief. Busy Bees wins because Willie did not need to quarantine due to existing CDC guidelines. Willie wins because Busy Bees retaliated. There are multiple correct answers, and then not sure.
Okay, we'll move on as once we see that the numbers stop shifting to different results.
We don't want anyone to be influenced, right, by the other answer choices.
Okay, looks like we're getting close here. All right. The first answer, Busy Bees wins because Willie lives in an at-will state. Well, that could potentially be a correct answer. However, the important thing that I tell employers about the concept of at will is that sure, North Carolina is an at-will state, and there are many states across the country that are at will. However, if an employee claims that it's a wrongful termination based upon one of the protected categories under Title VII, or one of a protected category under state laws, such as complaining about safety conditions in the workplace, or complaining about wage and hour issues, or having a workers' comp injury. In that situation, at will goes out the window, and the employer has an obligation to show that the actions it took were for legitimate business purposes. So A could have some correctness to it, but it also could be problematic.
I think B is a similar analysis. Busy Bees wins because an employer has a right to take action, even if it is done under a mistaken belief. And I think in this circumstance, it would be, and a lot of you said this in the comments before, that it seems like a harsh punishment that's not flexible at all, right? And here it sounds like based on the facts we had, Busy Bees decides to terminate him just for not showing up. And they just believe that guess that he's lying because of this rumor that's going around. And there's a lot of risk in doing that, and not at least engaging and trying to figure out if there's a true basis for termination. So I think this would not be the best answer.
And I can see C only has 6% right now. But C is one of those answers that is a little tricky as well, and it comes with some risk, especially depending on where you are. As we mentioned before, while the FFCRA's protections are not still in play, you may be in a state that, you know, could have some of those protections for people who are out due to COVID-19 exposure. But the tricky part about C here is that Willie thought he was following the existing CDC guidelines, but here he's incorrect. Currently, the CDC says that if somebody's been fully vaccinated and they've had their doses and their time has gone by, even if you are around someone who has been confirmed positive, you don't necessarily have to quarantine unless you are also showing symptoms. So it's a delicate situation here because Willie thinks that he's doing the right thing, even though technically under the CDC, you know, he's not under the most updated guideline.
Okay, then we get to D, which we had 12% people select. And it says Willie wins because Busy Bees retaliated against him. Well, as we mentioned in the previous segment, the FFCRA, which came into effect last April and expired as of December 31, the anti-retaliation provisions there are no longer in existence. However, as Justin mentioned, there could be other states that that do have these protections, and you have to be cognizant of those. And then there, you also potentially could be looking at ADA retaliation. So those are certainly some things that you have to take into consideration. And I see one person has said, Willie should have asked before deciding to stay home. Obviously, communication is always an important factor, and that is certainly something that the company could say, you should have called us and we could have told you that you didn't have to get tested as long as you were not showing symptoms. So that is definitely a good point. Justin, I know you looked at this issue for a client recently. Can you name some of the states that have the protections, the anti-retaliation protections?
Yeah, so New York actually has a pretty strong law that kind of handles a lot of the actual paid leave and whatnot that needs to be handled. But of course, coming along with that, you see a lot of the actual retaliation protections as well. And New York's law is pretty extensive, and we actually have gone through and drafted some addendums to try and make sure that we, cover all of that and, what it entails. But, for them specifically, it has not only the retaliation piece, but it has pay for it as well. So the leave, is going to be paid.
And so I think moving on to the next, and actually I have the list of states, Arizona, California, Colorado, Connecticut, Hawaii, Maryland, Michigan, Nevada, New York, Oregon, and Washington. They all have some type of law, whether, and that goes to Justin. I just knew that he had done that research and I had it. And they have some type of paid leave or retaliation about COVID-19. So if you have an employee working remotely from there or in person, just be careful about any action taken against them as it relates to COVID-19. That gets to selection E. There are multiple correct answers. 55% said that. I think it's probably the right answer. And I think it goes back to what a participant messaged us and said, Willie should have asked before deciding to stay home. I think because Willie is in North Carolina and we don't have one of these specific statutes protecting individuals regarding COVID-19, and because the FFCRA has expired, it may very well be that the employer would win in this lawsuit because we are an at-will state, and the employer could say he didn't call in, he just decided to stay home, and it was insubordination, and we can, if he's not under a contract, he's at will and we can terminate him. Now, what impact is that going to have on your workforce? Folks who know that he truly was exposed and he was trying to follow guidelines. And in particular, what if your company had not issued a policy about if you're fully vaccinated, it's okay for you to come in, and employees didn't know about that or know about the CDC guidance. That just, it's really not good for employee morale. And there could be some, as we call them, creative legal arguments for that lawsuit. And so you don't want to be sued. We want to stay away from that. So I think that's where there's, even though it might be possible that the employer would win, why would we want to take that risk?
And then I can see that we've got a growing crowd of not sure from the last go around. And like we said before, these are pretty tough questions, and trying to decide on what to do, not sure sometimes is the answer. And sometimes all of the guidance as to a specific state could make it change. So not sure is not actually a bad answer in some of these.
Yeah, and in fact, a question just came in: could the employer have asked first before firing? There's a couple of different ways you can interpret that. Should they have asked their legal counsel? Self-servingly, I will say yes. You absolutely should in this situation. And getting back to what Justin and Emily just said, you might win, but do you really want to be in litigation in that situation in the first place? If it's a situation where you have, it doesn't appear to be a slam dunk, then you've got to proceed very cautiously if you're going to take adverse action. So moving on to our next situation, and this is one that I think when I started practicing almost 28 years ago, I never thought we would be having these discussions, but it is absolutely one that we're having to deal with on a regular basis. So here's our scenario. Some of the states in which Busy Bees operates have passed legislation making marijuana legal. Some of those states also have statutes that prohibit any adverse employment action against employees participating in lawful activities outside of work. And I can tell you just, I'm doing a side here. Virginia has just passed one of these laws making marijuana legal. And North Carolina is a state, and there are many states that do have statutes that prohibit adverse employment action against employees participating in lawful conduct outside of work. So moving on with the scenario. Busy Bees has a company-wide zero tolerance drug and alcohol policy. And as you know, many companies have those. As part of its return to work initiative from the pandemic, Busy Bees is giving random drug tests in all locations. And remember, Busy Bees is a multi-state company. One employee who is drug tested is Bob Buzzed, who has severe arthritis and fibromyalgia. And he tests positive for THC. THC is the substance in cannabis or marijuana that you would look for to determine somebody has tested positive or it has marijuana in their system. Bob claims he has never smoked marijuana, but instead uses CBD oil for joint pain. So here's the question. Can Busy Bees terminate Bob? And answer A is yes, because Bob violated their zero tolerance drug and alcohol policy. B, yes, but only if Bob lives in a state in which marijuana has not been legalized. C, no, if Bob lives in a state in which marijuana is legal. D, no, if Bob lives in a state in which there is a state law prohibiting punishing employees for using lawful products outside of work. E, there are multiple correct answers. F, not sure.
And I see we're rolling in and the answers are still kind of flowing and balancing themselves out, but I'll start with A, as it looks like A has kind of stopped moving a little. So A is yes, because Bob violated the drug and alcohol policy. Similar to what Ken was saying as he was reading the call of the question, it depends on the state that you're in for A. While in some states, violation of the drug and alcohol policy, you're going to be able to, abide by that policy. In other states, if it's a state where marijuana has been legalized or, where they protect the use of legal products, you may have a problem trying to terminate based off that policy. So A is one of those questions where the lawyer answer of it depends kind of comes into play.
Okay, it looks like we had a few people select B. Yes, but only if Bob lives in a state in which marijuana has not been legalized. So marijuana is not legalized in North Carolina, for example, and several other southern states. So could that be correct? And it's kind of like Justin just said, it depends. Is there a statute that says the person shouldn't be punished for doing things that are legal outside of workplace? And this is one saying that marijuana has not been legalized. So this could be your right answer.
Similarly for C, and we're getting tricky on you, no, if Bob lives in a state in which marijuana is legal, and no one answered that one, but I think it's similar to B. And the issue here is, for the states in which that marijuana has been legalized, it's under very particular circumstances. And most of the time, employers still have the right to prohibit employees from being intoxicated under the influence of any intoxicating substance while they are working, or otherwise that being under the influence negatively impacts how they can perform the essential functions of their job. And so this becomes a complicated answer that would take there's lots of cases out there about it, but is having THC in your system, is that enough to show that you are under the influence, or that the employer can then have the right to terminate? And that, again, very much depends on state law. I saw someone just said, isn't marijuana still illegal federally? That has precisely been the issue in all these cases, is doesn't federal law trump or supersede state law? And there's been varying different decisions on that point, because there are these state laws that are trying to protect employees when it comes to their lawful use of lawful products outside of work, or if it's medically based. So that I think there's been some decisions saying that there isn't, that preemption doesn't necessarily apply to those circumstances. Very complex issue, depends on where you are in your jurisdiction. But I think most people stayed away from B or C as the right answer.
And going to D is no, if Bob lives in a state in which there is a state law prohibiting punishing employees for lawful products outside of work. So D is one of those answers that seems like it's definitely the right answer, but then you have to think, and I saw somebody put it into the comments earlier, it depends on Bob's job as well. So even for states who allow the use of, lawful products and who have legalized marijuana even, there's usually a carve out in the statute for federal contractors, or, for an example, if somebody is a CDL driver, like the comment said, they actually are still under the federal regulation, and you'll typically see a carve out in any state law for that situation. So D is another one of those, similar to what Emily was saying. It's a complicated situation, but depending on the actual employee's duties and their job, D could be incorrect still.
And that's correct. We actually had this case where a person that was a driver and was required to have a CDL. I mean, he had an actual doctor's note showing that he was supposed to be taking CBD oil, and he swore that he never used marijuana. And it's scientifically proven that if you have enough CBD oil in your system over a period of time, even though the amount of THC is so minimal, it can stack up and you actually can fail a drug test and appear to be on marijuana, even if you've never had marijuana in your life. And so it is a real possibility. And the employer actually wanted to work with this employee and not terminate them. But the problem was, under DOT regulations, a CDL driver who tests positive, which this person did, they were required to go through a rehab program, a 30-day rehab program. And this person was turned down from 2 different rehab programs because they said, you don't have a marijuana problem, you're on CBD. And they refused to take him. And unfortunately, DMV ended up revoking his CDL. And so because this guy no longer could do the essential functions of his job, which are driving, the company had no choice but to terminate him. So in that situation, D would not be a correct answer. Normally it would be. And then if you look at E, there are multiple correct answers. There are a lot of different circumstances if we make certain assumptions that we could have different correct answers, and we've already addressed those. And so that E is a pretty good answer. Again, you have to assume certain facts to get there on different of the answers. And if we take pieces of each one of A, B, then we can probably get there and say that yes, busy bees can terminate Bob.
And F, again, not sure. I'm in that boat with you, 8%ers. But I do want to point out, again, the lawyer and me reading this fact situation, saying that the busy bee decided to do random drug tests when everyone came back from being remote. Make sure that your state doesn't have particular requirements for the notice that you give to folks. And North Carolina does have really strict requirements on how you can drug test employees, the testing mechanisms, and also the notice you have to provide. And so if you don't have a policy saying that you can randomly drug test, I mean, you may be able to, but you just really need to make sure you have the notice and authorization. You meet those requirements in North Carolina. There's other states that have similar requirements, and New Jersey just came out with some really unique laws that I know Justin's looked into for drug testing. So just be really careful there. So to me, I'm like, well, maybe there are some more issues here that we don't really know about. And then to piggyback on what Ken said, that this issue is coming up more and more as far as employees taking a lawful substance, a CBD that has a low level of THC that is lawful under North Carolina law, but some argue is not lawful under federal law. And the issue there too, just from what I've seen, is whether it really those THC levels are beneath the federally or the state level. If it's provided from a reputable source, but this is an evolving area, and at the federal level, it's really unclear. So I think it'll be something that we see a lot of changes in the coming months and years.
Right, and piggybacking on that, when you get right down to it, it would be up to the employee to prove they haven't had marijuana, and that's proving a negative is very difficult, because how do we know the person never did actually use marijuana? Because marijuana stays in your system for pretty much a month. And that's in the CBD oil, it stays in your system as well. And that's why it can stack up and you can become THC positive. Now, people went on the chat, said alcohol is legal, but not allowed. What they mean is not allowed in the workplace, or you're not allowed to be impaired in the workplace. Wouldn't this be the same? Yeah, I mean, it's the same, except we know when somebody's impaired by alcohol, because you can go and have a blood alcohol test done right then. And if they got any alcohol in their system, and then you pretty much know they had been impaired on the job, whereas the THC could have been from the weekend before and it's still in your system. And unfortunately, the tests are not sophisticated enough to determine, did the person smoke it right before they went to work or on a smoke break, or was it several days earlier? So that's what's so difficult about this issue, and is one that is evolving. And let's see, I think we have one new message. Aren't there new testing out there for recent marijuana use, or is that still in the approval process? There is not testing that is widespread, that is reliable enough to pass the smell test yet. Eventually we'll get there, but at this point that's still an open question.
I believe LabCorp has been developing, if I remember correctly, has been developing one, but I haven't heard that it's reliable yet.
So going into our last and final role play, Harry Hive, 82 years old, is Busy Bee's oldest and longest tenured employee. He has plans of retiring and would like to continue working. Oh, he has no plans of retiring and would like to continue working until he physically cannot come to work. Harry's health has declined in recent years, and he has to miss work more frequently due to various medical appointments. He also has requested to work remotely indefinitely. Unfortunately, his job performance has slipped over the past couple years. Previously, Harry was a top performer, and now he's more of a middle of the pack at best employee. His supervisor is getting increasingly frustrated with Harry being out of work for medical appointments and wants to train someone else to take over for Harry. Harry has complained to HR that his supervisor is discriminating against him because he is not adept at technology like his younger coworkers.
So what would you do if you were the decision maker in this situation? A, have a frank discussion with Harry. B, start writing Harry up for every deficiency to build your paper trail. C, offer Harry a severance package so we can make the situation go away. D, A, B, and C. E, change Harry's job responsibilities to accommodate him. Or F, none of the above.
Well, it looks like we have a lot of varying answers here, which is exciting. Because this is a really tough situation, and I think something that is common with our workforce, with employees that are under the Americans with the Age Discrimination and Employment Act, or the ADEA. Any employee over the age of 40 is protected from age-related discrimination. But then it's even more complicated as we get into even more aging workforce, particularly when the supervisor is younger. So it looks like we've slowed down a little bit. So A is have a frank discussion with Harry. I think that's always a great option. And when you say have a frank discussion, I mean, the last part of the scenario that Justin read was Harry has complained to HR that his supervisor is discriminating against him because he is not as adept at technology as his younger coworkers. Well, we need to make sure we address that complaint, right? Why do you think he's discriminating against you? How is he treating you differently? Give us some specific examples, and investigate as you would normally investigate. I think that's objective number one, but also having a frank discussion with him about why he wants to work from home remotely. If that's not, if we need him in the office, if we feel like he's not performing, we need to be upfront with him and frank. So I agree with it on that point, but we need to make sure that we're taking his complaint seriously.
And B, start writing Harry up for every deficiency. That's what some employers actually want to try to do. They want to start creating a paper trail so that they can essentially do what it is that they ultimately want to do and try and, you know, push Harry out a little more. But the issue with that is, are these things that you would normally write someone else up for? Are these situations that everyone is being written up for, or are you finding a reason to single out Harry? And if it's the latter, you're almost giving him his smoking gun there for age discrimination case, which is what he's already claimed is happening to him. So I would say B is one to be wary of.
Okay, and looking at C, offer Harry a severance package. And I have some clients that do this in this very scenario. And if it works, great. The problem for the moment is addressed and you don't typically have to worry about Harry in that situation. However, you always have to consider, how about if it doesn't work? You know, I've gone and suggested a severance package to this 82-year-old person. If he says, no, I want to keep working for another 5 years or even longer if I can physically do it. And did you go and offer the 35-year-old that works right next to him a severance package? I mean, you know, it is a situation where you've got to be prepared if the answer is no. I'm not interested in the severance package for what you're offering. And so that's when we have to be very careful about. It can work if the person agrees to the severance package, but if they're not inclined to agree to it, then you're gonna have to backtrack, and we've got to have a plan B.
I really like option D, which is a combination of A, B, and C, because you can see this, you know, playing out in a lot of scenarios, right? Have a frank, you know, investigate his complaint, have a frank discussion about, you know, why do you want to work from home? You know, write him up if he, you know, in the fact scenario, it says that unfortunately his job performance has slipped over the last couple of years. How? We get that a lot. I'm sure you guys too. The manager says, oh, they're not performing as well. How? Why? What happened? Let's talk about it. So it might be that we do want to write him up and say, you know, you notice this change, you know, you need to improve your performance and do create that. And then one day Harry comes to you and says, hey, you know, I really think I want to retire. That might be the opportunity to say, well, actually, we might have a great severance package for you. So, and it might be because he brought it up. So I think D is a possible good answer.
And looking over at E, which says change Harry's job responsibilities. I think E may be another one of those situations where you may be setting yourself up for the discrimination piece when it goes to somewhat changing the essential functions of his job, and he already thinks that there's age discrimination being, you know, at play. The chances of him looking at that and saying, here's exactly what they did, here's how they tried to push me out of the door. When you change that, you may run into some more of that issue and be almost handing him exactly what he was looking for in that case.
And let's see, we did have a comment come out in, what about offer training if the technology area is what he is deficient on? Absolutely. I mean, that's a great idea. And you want to take as many issues off the table as possible. And, you know, following up on what Justin said, you know, do you even have an obligation to accommodate him other than he's indicated a deficiency in training, so you could provide the training. He's asked for an accommodation about working remotely. You got to address that. However, otherwise he's got job responsibilities that have to get done. And so do we really have to accommodate him come up with something on our own. So that's certainly something to think about. And then so, frankly, F is not a bad answer on this one, because there are circumstances in which virtually any of these answers could be chosen, because I guess a lot of people put D, which means they agreed with A, B, and C. And I think it's a piece of each one of these. For example, you always should have good communication with the employees, particularly when they're not functioning at the level or there's some frustration. Certainly, if we've not done a good job of documenting Harry's deficiencies, we should do so consistent with the way we treat other employees, as Justin said. You can certainly look for an opportunity to offer a severance package, particularly if the person opens the door for that discussion. There are accommodation obligations that we have to consider, but then there's some that we may not have to consider because he hasn't even asked for them. So, and also we have to think about our decision here is going to set a precedence for how we want to treat other employees. So anybody that chose none of the above or not sure, that is not a bad answer. So that concludes our LARP.